So, currently, I'm going to talk about the ex parte Young Decision, 209 U.S. 123, 1908. This is in relation to the 11th Amendment. So you had the 1908 ex parte Young Decision. And what this decision allows citizens to sue the state, but now it was allowed in a roundabout way. It was a loophole. So the 1908 ex parte Young Decision is a loophole against sovereign immunity. So SCOTUS figured that even though the citizens can't sue the state itself directly, it can sue the public officials of that state. Right? Oh, that's a perfect loophole. So you can't sue the state, you can sue the governor. Right? You can't sue the nation-state social construction, but you can sue the governor, him or herself, as in their capacity as a private citizen, and who happens to represent the state. So this is kind of a fucked up decision, but how we got here, first you had the Chisholm decision. The Chisholm decision said that states can use the federal courts, citizens can use the federal courts to sue the states. Well, that freaked out some of the statists, some of the fascist, tyrannical, totalitarian statists, people that believe in the state, and so they passed the 11th Amendment. Now, the 11th Amendment, within 4 years, for an amendment, it got passed pretty super fast. 1794, the 11th Amendment is going to get passed by 10 states, and then eventually it's going to get ratified in 1798. So the 11th Amendment straight up says that you, as a citizen, can sue your own state. You just can't sue the other states. You can't sue the other 49 states, or 13 or 15, or however many were around in 1798. So the 11th Amendment says you can't sue none of the other 49 states, nor can any citizen from any foreign country sue your state that you live in, or America, you know, probably, but the state. So this was leaning towards sovereign immunity, right? So as a citizen of Tennessee can't sue Colorado, and a citizen of Australia cannot sue Colorado. So that's the 11th Amendment. The 11th Amendment did not put in the phrase, it omitted, because it banned citizens from other states from suing the state, and it banned citizens from other countries from suing the state, but it didn't ban citizens of that state from suing that state. So the 11th Amendment is very clear. It's very clear. Other people can't, the other 49, I can't sue the other 49 states, the other 49 states can't sue, the citizens of the 49 states can't sue my state. And also with the countries. So it makes sense to me that foreign countries can't sue us. It doesn't make sense to me that we cannot sue the other states. So I have a problem with the 11th Amendment. Half of it is wrong. 50% of the 11th Amendment is a bunch of bullshit, which is why the 11th Amendment is a crock of shit. It's a crock of shit. And then after the 11th Amendment has been passed, you got the Cohen's decision. The Cohen's decision upholds my interpretation that a citizen can sue their own state, and therefore a citizen could sue their own state. They could use the federal courts to sue the state of, you know, Tennessee or what have you. After the Cohen's decision, you had the Hans v. Louisiana decision. The Cohen's decision was 1821. So the Cohen's decision happens within 20 years after the passing of the 11th Amendment. Then 1890, the Hans v. Louisiana decision overturns the Cohen's decision. And Hans v. Louisiana established the modern doctrine of sovereign immunity. So the Hans v. Louisiana case, the 1890 Hans v. Louisiana decision, fucked up everything. They fucked up everything. The decision says now the citizens cannot sue their own state. There is sovereign immunity. States are immune from lawsuits. Fantastic. Nobody should have sovereign immunity. Sovereign immunity. Immunity to, you know, never ever get in trouble for any of the shit they do. Now we're at the ex parte Young decision. So 1908. This is after the Hans decision. So sovereign immunity has been established. Sovereign immunity. So not only can the citizens of other states can't sue Colorado, I can't sue Colorado. The citizens of other states and other countries can't sue Colorado, I can't sue Colorado. No citizen can sue Colorado. That's how the Hans decision interpreted the 11th Amendment. The 11th Amendment was initially only half wrong, but after the Hans decision, it became 100% wrong. So the 1908 Ex parte Young decision, this allows a loophole for citizens to be able to sue the state. You can sue the Secretary of State, you can sue the Attorney General, you can sue the governor, you can sue them in their individual capacity as a private citizen. And so for sometimes you can say they're a state actor, other times you have to say they're a private citizen, but the 1908 Ex parte Young decision breaks sovereign immunity by allowing the individuals of the state who represents that state to be sued. So the details of the Ex parte Young decision, 1908. So you got the state of Minnesota, who's being run by Edward T. Young. He's the Attorney General of Minnesota. Okay, not even the governor. He's just the lead law enforcer. Which, is that more powerful? Anyways. So Edward T. Young is the Attorney General of Minnesota. Now Minnesota passed laws, the legislature. They passed laws that limited what railroads could charge in that state and established severe penalties, including fines and jail for violators. So they were saying that railroads could not price gouge. They set a price floor for railroads, saying if you charge more than this, then you're going to get in trouble. Now, they're going to sue the shareholders of the Northern Pacific Railway. They file a lawsuit in the United States Circuit Court for the District of Minnesota, asserting that the laws were unconstitutional as violating the Due Process Clause of the 14th Amendment, as well as the Dormant Commerce Clause. Dormant commerce, so that means they're not allowed to regulate the railroads. The decision for this railroad question is going to come down quickly. Justice Rufus, right, that he must be smart, Rufus Wheeler Peckham, he quickly said that the Minnesota laws with respect to the railroad rates were unconstitutional. They quickly established that, and then they moved right on. So I don't know the exact details why. Why is it, you know, the state of Minnesota cannot regulate the fares of railroad companies? So anyways, the shareholders sued the railroads to prevent them from complying with the law, and then they sued Edward T. Young, the Attorney General of Minnesota, to prevent him from enforcing the law. Isn't this a genius case, right? So you got shareholders, which isn't citizens of Minnesota. They're citizens of Minnesota in lots of other states. So you got citizens, right, the corporate citizens. Really, it's the Northern Pacific Railway, but in order to make sure that the shareholders are separate from their company, they're going to go ahead and sue the Northern Pacific Railway in addition to Edward T. Young. They're going to sue their own company, and they're going to sue a member of the government, the Attorney General of Minnesota. And so Edward T. Young is who this court case is named after, ex parte, which I think is Latin. You probably could say the 1908 Young decision, but the 1908 Ex parte Young decision, because it's named after Edward T. Young, they argued that the 11th Amendment, he argued that the 11th Amendment, which prohibits states from being sued by citizens of other states, meant that the federal court didn't have jurisdiction to hear the case. And so, according to the Hans decision, he was, you know, correct in using the court interpretations of the damn thing. And the federal court, the Federal Circuit Court, still issued an injunction against Young to stop him from setting the prices of the railroad companies, and also reinforcing the role of the federal courts in disputes between citizens and a state. So when they're hearing all of these legal questions, they themselves are implementing questionable legal tactics. So he's saying that they didn't have any power to sue him in the federal court, and the federal court was like, not only do they have the power, but we got the power to issue an injunction against you to stop your law, and then we have the power to throw you in jail for contempt. So the Attorney General of Minnesota is going to go to jail for this. I don't even know if he gets out. So the next day, after the Federal Circuit Court had issued an injunction against Young, the private individual, in his capacity as the Attorney General of Minnesota, because they can't sue the state, but they can sue one of the officers, he They issued an injunction, and then his response was to file a proceeding in Minnesota State Court to force the railroads to comply with the statute. So the federal court issues an injunction. He issues some sort of, court case thing to force the opposite of an injunction. He issues an anti-injunction. No, fuck the federal court. You're going to do what the state court says. And so far, he's actually in accordance with the Hans decision. And so the federal court is essentially, again, taking more power, where they're not needed. So the federal Supreme Court, they ordered Edward T. Young, the Attorney General of Minnesota, to explain his actions. Why did you file a proceeding in Minnesota State Courts to force the railroads to comply with the statute? Edward T. Young, he said his 11th Amendment claim. The 11th Amendment says that states cannot be sued by citizens of other countries or other states, and the shareholders of the Northern Pacific Railway were definitely citizens of another state. So when he said that the 11th Amendment prevented the federal court from having any jurisdiction in Minnesota, that's when he was held in contempt. Edward T. Young was placed in the custody of the U.S. Marshal Service, and then Edward T. Young filed a petition with the United States Supreme Court for a writ of habeas corpus for his release. So I have no idea if Edward T. Young, the Attorney General of Minnesota, ever got out of federal jail for his contempt of court charge. So this is so crazy. This is all this is so goddamn nuts. The sovereign immunity clause is bullshit, but of course, one of the members of government who would be shielded by sovereign immunity, of course they're going to be like, wait, are we immune from, all of our behavior? We probably shouldn't be, but then again, we absolutely should be. So the judicial branch goes ahead and adopts the sovereign immunity clause for the state, which is 3 branches of government. So they go ahead and cover the executive, judicial, and the legislature with this sovereign immunity bullshit. So the opposite of sovereign immunity would be contempt or, disorderly conduct charges. So just some tiny-ass bullshit just to fuck up your life. So the state has complete immunity. You can't even sue them if they steal your money. You just have to accept it. You just have to take it. So they adopt this sovereign immunity thing. But then when it comes to contempt of court, so they have, the citizen has 0 power to sue the state, and yet the state has absolute power to say, even if your demeanor in court isn't respectful enough, then you'll go to jail. So that's fantastic, right? The citizens have no power, and then the federal courts have all the power. So I think it's crazy that the federal courts are able to get away with a lot of this. The state could have ignored all these proceedings and not responded or not shown up. How he was able, how they were able to throw Edward T. Young in jail is pretty impressive. Perhaps he didn't put up enough fight, or perhaps he allowed them to take more power than what they deserve, because ultimately he was correct. But without this case, we wouldn't be allowed to sue the states. So now we have a mechanism of how we can sue the states. So the 11th Amendment doesn't bar a citizen from suing their own state. It bars other citizens from other countries and states from suing their own state. So the Hans decision, the Supreme Court interpretation of the 11th Amendment, is what eventually gets the doctrine, creates the doctrine of sovereign immunity. And the sovereign immunity is bullshit. It wasn't in the Constitution. It wasn't in the 11th Amendment. They're taking power that they were not given by the Constitution or the Amendment. So the 1908 SCOTUS Decision. So what does the Supreme Court of the United States in 1908 say about this ex parte? How did they get, what was the rationale? How did they get to their decision? So 1908, ex parte Young Decision, SCOTUS, Justice Rufus Wheeler Peckham, he says that Minnesota laws with respect to the railroad rates were clearly unconstitutional. That's clearly right. You overstepped your bounds. So automatically, yes, can citizens sue in a federal court? Not only can they sue, but they can get a victory. So Rufus Wheeler Peckham says the railroad rates were unconstitutional. Therefore, everything the Attorney General did was illegal. They moved on to whether the state official could be enjoined from prosecuting violations of such laws. Injunction to stop the person from... So the court also noted that although a number of cases had held that the state itself could not be sued, those cases did not prohibit enjoining a state official as an individual from carrying out some task out on behalf of the state. Is the state not made up of state officials? So you can't sue the state, but you can sue the people that operate the state, so you can sue the state, as long as you know that loophole. As long as you know that you must sue the governor or the attorney general or the secretary of state directly, and you can't sue the state of, Colorado, Tennessee, Montana itself. You can't. Okay, so there's Edward T. Young. He's going to say, look, I'm just, carrying out the laws of the state of Minnesota. He was enforcing the laws of the state of Minnesota. So essentially, he thought he was operating in his official capacity. Now, 1908 SCOTUS is going to disagree with Rufus Wheeler Peckham. Justice Rufus says that when a state official does something that's unconstitutional, such as enforce the law that the legislature passed when it comes to regulating railroad rates, they were regulating it. They weren't putting them out of business. They were just making them pay or charge an acceptable standard. And so they may have made the railroad rates lower, but they weren't trying to run the railroad out of business just to charge better rates. So I think that what Minnesota was doing was right and proper and legal. I would like to know, was the Commerce Clause dormant, so you can't, the railroad, goes through the states, so you're not allowed to regulate I don't know. So there was 1908 SCOTUS. Rufus, he says that since the Attorney General had broke the law with the railroad rates, he was enforcing an unconstitutional law, therefore he was criminal. He wasn't an official of the state in that capacity. He was actually a criminal, doing his own criminal shit. So the Supremacy Clause of the Constitution means the Constitution overrides all the laws of the states, but then they're not allowed to sue the state. So anyways, invalidating any contrary laws. So if a law is contrary to the Constitution, therefore it's illegal. If you enforce an illegal law, you are a criminal, and a criminal can get injunctive relief or be thrown in jail. So the 1908 Ex parte Young decision created two brand new legal fictions. One fiction was that the suit is not against the state, but merely against the individual officer who cannot be acted on behalf of the state when he enforces a law that is unconstitutional. And number two, an individual could be a state actor for the 14th Amendment purposes, which only prohibits unconstitutional acts by the state and those who represent it, while remaining a private person, a private prison, for sovereign immunity purposes. So the legal fiction is that the Attorney General could both represent a member of the state for the 14th Amendment, or he could represent a private person for the sovereign immunity purposes. So because, the 11th Amendment was bullshit to begin with, and then the Hans decision takes too much, now we're in fucking no man's land. This shit is nuts. This shit is crazy. So they're saying that essentially the Attorney General could be both a private citizen and a state actor depending on the whims of the court. If the court feels like he's a state actor versus an individual, again, this is a loophole, and I agree with the 1908 Ex parte Young decision because it pokes a hole in the Hans decision, and it pokes a hole in sovereign immunity. So the 1908 Ex parte Young decision is a decision in the right direction. And how they got here and what they were doing, they were defending the railroad corporations, which I agree with the Minnesota case. So the decision itself is fucked up and backwards. They fucked over a good man enforcing the laws of his own state to make sure that the railroad companies were charging a decent wage. So they fucked over a good guy doing good things, And so if you look at the decision itself, that can be instructive on where they actually stand. So again, you know, the corporations and the government, they took more power, but by taking more power, they also allowed citizens to be able to sue, not only citizens of their own state to sue the state, but citizens of other states to sue a state, as long as you know, specifically pointed out the individual, you know, official. So now, Justice John Marshall Harlan's going to be pissed off about this. He sees all this shit, and he's like, what the fuck is going on? Okay, so let's see. Okay, so ultimately, what the 1908 Young decision said, that the Supreme Court, lawsuits can be brought by citizens to enjoin or to issue an injunction against individual state officials from enforcing unconstitutional laws in the United States District Courts. So the federal court does have power. They have injunction power to stop unconstitutional laws, and citizens may enforce. The federal court to sue the states to stop them from enforcing unconstitutional laws. Justice John Marshall Harlan angrily dissented because he said 1908 SCOTUS was on some bullshit, and they knew it too. So John Marshall Harlan, he said the reason why Young was sued, and he's absolutely right about this, he said the only reason why Edward T. Young was sued was because he represented Minnesota. The reason why the Attorney General was sued in his capacity as a private citizen was only because he was the Attorney General. And so therefore, this is a lawsuit against the state. So John Marshall Harlan saw the bullshit, saw that this was a fig leaf of a power takeover. John Marshall Harlan also had contended that constitutional rights can be enforced by suits in the state courts. So when it comes to the 14th Amendment, they're saying that the rights and freedoms of Americans can be upheld in federal courts via the 14th Amendment. But John Marshall Harlan says, well, that's not necessary to go to the federal court. The state court could also enforce your freedoms. So the state court could take precedent first, and then the federal courts can come in later. According to John Marshall Harlan, you could go to the trial court in the state first, and if they did not enforce the Constitution, then it would be appealed up to the state Supreme Court. And if they didn't enforce the Constitution, then it could be appealed to the U.S. Supreme Court. So John Marshall Harlan said, you know, let the states figure this shit out themselves. At first, give them a chance in the, you know, trial court, and give them a chance in the Supreme Court. If they still fuck up, then you go to the Supreme Court. So that's an interesting legal argument. John Marshall Harlan, I think, ultimately is wrong overall on this. But he essentially saw that, you know, what they were doing. They were breaking sovereign immunity to protect the railroads company's power to fuck over an attorney general of a state that was trying to regulate their rates. And because they did that, they allowed states to sue the government, at least when it comes to an injunction to stop an unconstitutional law. So, therefore, once again, the 1908 ex parte Young decision, the federal government figured out a legal loophole for themselves to where they could enforce the U.S. Constitution and Code, not by suing the state itself, but instead by suing the specific individuals who ran that state. So that's the 1908 ex parte Young decision. Okay.